Chairman Boyd. All right, Representative Pearson.
Thank you, Speaker. Sponsor, if you would, in Section 1B, it says an employee shall not join as a party plaintiff in any civil action that is brought under this chapter by an employee, person acting on behalf of an employee, or person acting on behalf of all similarly situated employees, unless that employee first gives written consent to become such a party plaintiff, and that consent is filed with the court in which the action is brought. So, does this mean a person who wants to bring a civil suit would have to, say, get something notarized, would have to write a letter and take it to a court and say that I want to be a part of a civil suit? I'm trying to understand this process, particularly because in our community, when we deal with polluters and things like that, a lot of folks have illnesses, et cetera, that they may be experiencing. And this looks like it's kind of putting a barrier up between them being able to join a civil suit without having to actually go to a court, having to get this letter written and approved. And so could you speak to that?
Chairman Boyd.
Thank you, Mr. Speaker. Can you take me one more time, but very short, can you ask that question one more time? I'm flipping here. I'm looking at it with you. Ask that question one more time.
Representative Pearson.
Okay, I got you. So for people who are involved in a civil suit, right, let me clarify, in the initial language, the employee had this process of having to go and get consent from a court before the civil suit is brought. With this legislation that we have, what is the process for an individual to be able to join that civil suit?
Chairman Boyd.
Thank you, Mr. Speaker. Basically, what this section is saying is that the employee would have to give their consent to being included in that lawsuit. And so how the plaintiff's attorney would go about gathering people that are interested in being involved in that would be up to them. But what this section really is speaking to is that somebody can't be included in it without their consent, which seems like a reasonable thing to put into the state law.
Representative Pearson.
Okay, thank you for answering that question, and I appreciated Chairman Freeman's questions as well, because when we're looking at this definition of work, is it specifically, I mean, the definition's here, right? Not doing certain things during certain times, all that. Is the intention of that to prevent people, lawyers in your case, from calculating just an extraordinary amount of money for potential suits?
Chairman Boyd.
Thank you, Mr. Speaker. So, to give you a little bit of background on this, there have been a few states that there has been class action lawsuits that were successful. And the reason they were successful, even though we already have federal law in the Fair Labor Standards Act and the Portal to Portal Act of 1947, is it was found that those states were not consistent with or were not complying with the federal law. So once they got outside of that, they were kind of on their own. Once we recognized that, we said we just need to tailor our state laws to match those two things, the Fair Labor Standards Act in the Portal to Portal Act of 1947. So we're just kind of making ourselves consistent with the federal law, which would give us some level of protection if there were a class action lawsuit. And those actually kind of spell out what is considered work and what is excluded in the definition of work.
Representative Pearson.
Thank you.